Thank you, Mr. Hevner. Welcome to the April Jackson docket of the Tennessee Supreme Court. We are so pleased to be in person for the first time in more than 2 years. And we want to welcome everyone who's watching us by live stream on YouTube. And I want to note that today is the first day for our new Justice Sarah Campbell, to sit with us. She's already a valuable member of the team, and we know she's going to do a great job. We're just happy to have you, Sarah. Welcome.
Thank you.
We have 2 cases this morning. In just a moment, Mr. Hivner is going to call out the first case, but each side has 30 minutes. So when the appellate comes up, if you wish to reserve some rebuttal time, please let us know at that time. Jim Hivner, our appellate court clerk, will now announce the first case.
State of Tennessee versus Marvin, Maurice, Deberry.
Good morning, Your Honors, and may it please the Court. Ronald Coleman, on behalf of the state, I'd like to reserve 5 minutes of rebuttal time, if that's all right. The state is asking this court to hold that the lesser penalty provision of the criminal saving statute does not apply where the legislature does not provide for a lesser punishment, but instead simply repeals a criminal offense. And in accordance with that holding, we ask this court to reinstate this defendant's initially imposed sentence and fine. To provide some background for how this case got here, the defendant was pulled over for a broken taillight, and officers discovered that his license had been revoked due to his status as a motor vehicle habitual offender, also called an MVHO. Along with several other offenses, he was charged and convicted of driving after being declared an MVHO, which was a Class E felony codified in Tennessee Code Annotated 55-10-616. At a sentencing hearing, the trial court ordered the defendant to serve a 5-year sentence and stated that the $1,500 fine imposed by the jury would be upheld. This case took a strange turn when the General Assembly passed an act which deleted Section 616, and that bill became effective between the defendant's conviction and sentencing. The defendant pointed out the repeal at his sentencing hearing, and he reiterated it in his motion for new trial, arguing that that he was entitled to a lesser sentence. Reasoning that, quote, no penalty is a lesser penalty, the trial court entered an order vacating both the sentence and the fine for the conviction dealing with MVHO. The state appealed, and the Court of Criminal Appeals determined that the deletion of Section 616 was an act of reducing the penalty to nothing, which constituted the imposition of a lesser penalty. Now,
Mr. Coleman, can administrative costs, court costs, and maybe possible fines be a lesser penalty?
No, Your Honor, certainly not. This court has held that the costs associated with the reinstatement of a driver's license do not constitute a penalty.
What are you basing that comment on?
So we're basing it on both Lewis and TCA 55-50-323, and those stand for the proposition that the revocation of a driver's license is not a penalty, in which case the fees associated with that should not be considered a penalty either. Indeed, more to your point, Justice Page, is that the reinstatement of a driver's license and any costs, fees, anything else associated with that is entirely optional. And usually criminal defendants do not get to pick and choose whether they follow a punishment, whether they get to adhere to that. So because it is optional, and because the language and the amended language in what is now TCA 55-10-601 states that someone may petition to reinstate their driver's license, it is completely optional and is certainly not something that this defendant or any defendant is required to do based upon a conviction for driving after being declared MVHO.
So, counsel, this is a statutory construction case, right?
Yes, Your Honor.
I want to isolate the language that you are asking us to construe. Is the language that we are being asked to construe in the act that amends or repeals the motor vehicle habitual offender, or is it in the saving statute?
The question we are asking this court to determine on statutory construction is what the lesser penalty provision language means
In the savings statute. So the phrase that you are focusing on is in the savings statute, and the phrase is lesser penalty. So the issue is whether no penalty is a lesser penalty, or whether the fines, et cetera, are a lesser penalty? Is that,
Yes, sure.
am I isolating the issue appropriately?
I think it would be more fair to isolate the entire savings statute, and the reason we think that this was a misinterpretation of the savings statute is because of the language highlighted in the second sentence. And so if you don't mind, I'll read the first and second sentence and then differentiate the two.
So basically, you're just saying you have to take the phrase lesser penalty in the context of the entire savings statute.
I think so, and especially in the context of the second sentence, and at least.
But there's no phrase in the first sentence of the savings statute that is particularly at issue, is it?
Correct.
Because you've said whether it's amended or repealed, ultimately, at the end of the day, doesn't make a lot of difference to your argument.
That's correct, Your
Okay.
Honor. And so the first sentence of the criminal savings statute, which has been around virtually unchanged for over 160 years now, holds that when a penal statute or penal legislative act of the state is repealed or amended by a subsequent legislative act, the offense as defined by the statute or act being repealed or amended, committed while the statute or act was in full force and effect, shall be prosecuted under the act or statute in effect at the time of the commission of the offense.
Mr. Coleman, can I interrupt you there for just a moment? Can you tell me how the state interprets the phrase "shall be prosecuted"? Do you interpret "shall be prosecuted" to encompass the punishment or penalty phase of the trial as well?
Yes, Your Honor. When you're looking at it logically, to interpret this any other way would to result in punishment-free prosecutions. And when you look at this statute, along with the statutes that surround it, it is very clear that the legislature expressly intends for a prosecution to involve a punishment. For instance, I believe Section 3911.114 says that if an offense does not have any offense classification, it is considered a misdemeanor. It says that if there is no penalty expressly provided for, then it will be punished as a misdemeanor, or a felony will be punished as a Class E felony. And so it's clear that the legislature wants something, when it is prosecuted, to be punished.
Do you think it's possible to interpret this statute so that the first sentence could apply to the prosecution, so the offense for which the defendant is convicted, and then the second sentence does use different language? It talks about the punishment imposed, so that the second sentence could apply to the punishment that's imposed under the subsequent act? Wouldn't that give meaning? Wouldn't that interpretation, I guess, give meaning to both sentences? One of the arguments you've made is that interpreting lesser penalty to include no penalty in the second sentence would render at least the repeal part of the first sentence superfluous.
And I think it would, Your Honor. I think it would render that it would sort of read out the language of that first sentence, again, because the legislature has clearly stated that they want punishment when there are prosecutions. I think there is sort of a loophole, if you will, where the legislature could sort of repeal an offense and in a separate clause, or even in that same clause, but expressly state that we are no longer, any punishment for an offense committed before this date is no punishment or something. The legislature could expressly do that, but the general savings statute, I don't think it can be read that way.
And so it's your position that the legislature would have to expressly state that in the repealing act, in the subsequent act?
That's correct, Your Honor, and that's because we presume that the legislature knows what the current state of the law is. And so when they pass an act, specifically when they repeal a criminal offense, we presume that they do that knowing the language of the criminal savings statute. But to your question, even if that was possible, even if they could sort of be read that way in harmony, that's not the case here. And that's focusing on the language of this second provision, the lesser penalty provision, which holds, in the event that the subsequent act provides for a lesser penalty, any punishment imposed shall be in accordance with the subsequent act. And so really the key there are sort of two clauses. One is provides for, and one is a lesser penalty. And neither of those clauses are here today. And that's because the legislature did not provide for anything. They simply deleted the criminal offense.
Tell me how that's not could not be characterized as an absurd result. If the legislature knocks down the penalty for an offense, then the defendant gets the benefit of the lesser penalty. If the legislature decides it's not an offense at all and there's no penalty at all, the offender is penalized according to the prior statute. So I understand your argument, but I'm having a hard time with that. There's just the basic fairness of it and how the legislature would have intended that.
I understand, Your Honor, and it's a bit of a tricky question, but I think part of it is that the lesser penalty provision is sort of itself what the legislature has done to be a little bit more fair. And part of it is that
So it only wanted to be a little fair,
when you look
not
at
totally fair, just a little bit.
Well, I think that's slightly correct, because when you look at the history of the saving statute, it was passed specifically to ensure that defendants don't sort of get off scot-free for flouting a law that has been repealed or amended. And so it's...
Were both of those clauses enacted at the same time?
No, Your Honor. The first sentence, the repealed or amended language, was enacted in 1858. And it, again, has remained virtually unchanged since then.
Okay.
In the 1960s is when the legislature added the lesser penalty
Okay,
language.
because sometimes you do get more of a Frankenstein result when it's amended. All right,
Agreed.
thank you.
Yes, Your Honor. And so when we're looking at this provides for a lesser penalty, here the legislature has simply deleted the criminal offense, and we know that they did that presumptively with knowledge of what the criminal saving statute holds, which is when it is repealed, you prosecute it as it was codified when the offense was committed. So the legislature, without providing anything else, has stated their intent for offenses that were committed before the repeal to continue to be prosecuted. And the second part of the language, or the second clause in that lesser penalty provision, is a lesser penalty. And the best example I can think of is to consider it similar to lesser included offenses. A verdict of not guilty or an acquittal is not a lesser conviction or not a lesser included offense. And so that language, again, we presume that the legislature used that language with specific intent. And so when they said we have to provide for a lesser penalty, they need to provide for some penalty. And that's why there has to be some punishment. And here there is no longer any punishment for committing the offense of driving after being declared MVHO.
Mr. Coleman, can I ask you a little bit about the arguments that transpired in the trial court? Did the defendant argue in the trial court that the administrative costs or fees constituted a lesser penalty?
No, Your Honor. The entirety of the argument, my recollection of the record, is that the entirety of the argument was sort of 0 is less than 5, and so no penalty is a lesser penalty.
So when was that argument first advanced?
If I can recall, it might have been brought up in a footnote or at arguments in the Court of Criminal Appeals, and then it was fully fleshed out just in the defendant's responsive brief in this court.
So the trial court never considered that argument?
That's correct, Your Honor. Well, so no, correct, that is correct. The trial court never considered the defendant's alternative arguments about what some other penalty could be.
What about the Court of Criminal Appeals? Did it ever consider it?
Based on the language in its opinion, I would say no, Your Honor. I would say it was not, to my recollection, it was not fully fleshed out either in briefs or in arguments. And again, the Court of Criminal Appeals held that the act of reducing the penalty to nothing was an imposition of a lesser penalty.
They basically said no penalty is a lesser penalty.
That's correct.
Yeah.
And again, because of these two clauses, that the legislature has to provide for a lesser penalty, our position is that that is a misinterpretation of the lesser penalty language of the savings statute. Very briefly, I'd like to point to this court's own decisions in Menke and Kesey and Tolley, which already has indicia of differentiating the two separate clauses of the savings statute. There they distinguished between, or this court distinguished between the repeal or redefinition of an offense, such as the theft, in which case the first provision of the savings statute applied, or the simple reclassification of a punishment, which is what happened in Menke and Kesey. This court determined that that was a reclassification of just the punishment, in which case it provided for a lesser punishment. And Other states have also followed this. To be fair, Tennessee is one of 16 states that I've been able to find that have any lesser penalty provision at all. At least I believe 38, if not more, of the other states have no lesser penalty provision. Defendants sort of just get the short end of the stick at all, to your question, Justice Kirby. And so,
So absent the lesser penalty provision, if there's no lesser penalty provision, so in these states that just have that, then a defendant who commits conduct that is prohibited by a statutory provision at the time the conduct was committed is prosecuted under and punished under the old statute, even if it's subsequently repealed or amended to provide for a lesser penalty. Is that right?
yes, Your Honor, in at least 38 of the states. I was able to find about 38, if I'm doing math right. That might be incorrect, 28, because we don't have more than 50 states. I apologize.
I thought
At
you were
least
adding
28.
I thought you were adding all the territories in D.C.
And at least I believe 28 of the states then, they have a saving statute that I was able to find. And in those states, to your question, yes, if an offense is repealed or amended, those defendants, if they committed the offense while it was still an offense, are subject to the full force of the law. And so that's our position, is that is how our saving statute should be interpreted as well, especially given the guidance of this court, given sort of the persuasiveness of cases like Rogers from Kentucky and Easton from West Virginia, where they have very similarly worded saving statutes with lesser penalty provisions. And so there. And again, to your point, Justice Campbell earlier, of whether this would be an absurd result, I think punishment-free prosecutions are sort of an absurd result. They don't foster justice. They don't help with judicial economy. And so when the legislature has said, we still want you to prosecute these offenses, and they have indicated based on the statutes around the saving statute that prosecutions should have some punishment, then I think the language is clear that we don't want punishment-free prosecutions.
So what happened here was, so there's a judgment of conviction entered, but the sentence was vacated. So does that conviction, this is a felony conviction, so does that felony conviction still carry with it collateral consequences for the defendant, notwithstanding the lack of any sentence?
Yes, Your Honor. It carries certain collateral consequences, but none of those are penal in nature. The Supreme Court has defined what penal is. The U.S. Supreme Court has said a statute is non-penal if it imposes a disability not to punish but to accept some other legitimate government purpose. And all of these sort of collateral consequences are designed with some other government purpose in mind, and they are not a punishment imposed for the conviction. It's the conviction itself. They're not a punishment imposed.
Well, if this defendant commits another crime, he still has an E-felony on his record, correct?
That's correct, Your Honor.
And the defendant would not be eligible to vote either, correct?
That's correct, Your Honor. Again,
I understand you're saying they're collateral consequences, but they are consequences.
Yeah, they are.
That otherwise would not be present absent the felony conviction.
That's correct, Your Honor. But again, that is not a punishment imposed. And to go back to the language of the saving statute, those consequences are not something that are provided for in the subsequent act. This act does not, the act in question that repealed driving as a MVHO as an offense does not provide for any lesser penalties, does not provide for any punishments whatsoever.
Could the Department of Safety get rid of the fees, the reinstatement fees, to which the defendant points at any time it wishes?
To my knowledge, no, they didn't, Your Honor. And
No, could they? There's nothing in the statute that
I think there is something in the
requires.
statute. I'm sorry, I did not.
Oh, sorry. No, that's okay. Is there anything in this statute, the reinstatement provision itself, that requires reinstatement fees?
There is nothing in amended section 601 that requires reinstatement fees. Those are found elsewhere, and I cite those in my brief, which are statutory requirements on the Department of Safety, and that is the guidance they use. But to a sort of larger point, those fees are not punishments. If they were, then we would be imposing a criminal punishment on every 16-year-old in the state who pays for their license. So we would be imposing a criminal punishment on me because I had to get my license back when my wallet was stolen. Everyone pays fees, and those are administrative in nature, and they do not constitute a criminal punishment.
Can I ask you about footnote 2 of your reply brief? You argue that amended 601, which now provides for this reinstatement provision, that doesn't apply to defendants who are convicted under old section 616 of driving after an MVHO revocation. So individuals who have their license revoked solely because of their status as an MVHO would be eligible for reinstatement, but individuals such as the defendant who have a conviction for driving after a revocation would not be. Is that an accurate characterization of that argument? I mean, is the defendant here actually able to get his license reinstated?
I'm not sure, Your Honor. I know he cannot follow specifically section 601 to get it, because again, that section points out that it has to be someone who has solely lost their license due to their status as an MVHO. So someone who has been declared an MVHO and has followed the trial court's order and not driven again, or at least not gotten caught driving again. And that's because of section 5550-501A3, which provides that your license is required to be revoked for at least a period of time if you were convicted of a felony. And so I think, if I remember that statute correctly, there's only a period of time. And once that period of time has passed, which it might already have, then the defendant can sort of go through process to get his driver's license.
But it would be
back.
under a separate reinstatement provision.
That's my understanding of the law, Your Honor, yes. And again, that revocation, this court has expressly held, because he lost his license as a felony, that's a consequence, but this court has expressly held that is not a punishment, and that was in, in Lewis.
As far as legislative intent goes, counsel, if we were to look at that, wouldn't it be a strong argument that this provision, this amended provision, is a part of the overall criminal justice reform and the intent was for a lesser punishment?
If I understand your question correctly, you're asking about the legislative intent of what the act repealing the offense
Correct.
does. And I think we can't get to that, Your Honor, because it very plainly, unambiguously, clearly repeals section 616. There is no question that section 616 does not exist. There is no criminal offense anymore, and that is really the only question that it comes to when we are then interpreting the saving statute. So it has been repealed, and it no longer exists. So at that point, we go to the saving statute. Our position is that the language is clear and unambiguous. The legislature has to expressly, quote, provide for a lesser penalty. They did not do that here. And even if you were to get into the legislative intent, it is very clear that the legislature intends for the saving statute to maintain criminal prosecutions and not punishment-free prosecutions, except for in the instance where they provide for a lesser penalty.
Is there any ambiguity in this statute? Any reason for us to look at the legislative history?
In the saving statute?
Either one of them.
No, Your Honor. The state does not think so. Again, the language is very clear, very unambiguous. And so this court can look at the plain language of the saving statute and of the repeal and determine that.
Is there any legislative history of the second sentence of the saving statute?
There is
that
a
was added?
slight amount, Your Honor, and I cite to it in my brief.
I mean, is there any relevant legislative history?
It is barely useful at best. It's sort of during their floor session, they provide a few examples and talk about adding this lesser penalty provision, but it does not go into depth.
Doesn't address a situation where there's no penalty.
No, Your Honor.
Okay.
Are there any states with saving statutes that go farther than, I guess, states that have this lesser penalty provision? You mentioned the 30-some-odd states that don't even have the lesser penalty provision. Are there states that, I guess, are even more protective of defendants and giving them the benefit of subsequent acts?
Yes, Your Honor. Of the 16 that I could find, there are 3 I would say that might have something that would go a little bit farther than our language. One is California, which is just a lesser penalty and abatement, just straight up. Another would be sort of Illinois, which deals with the lesser penalty by consent. So if both parties or if the aggrieved party consents to receiving that lesser penalty, which presumably they would, then they can get it. And there's also a lesser penalty by consent in Kentucky. The only other difference I can find is North Dakota has an automatic lesser penalty. As soon as it is provided, it's automatic, and Kansas says there's a lesser penalty if you've not yet been sentenced. But the rest have very similar language to us.
And to the extent courts in the states that have similar language to the lesser penalty language that we have here in Tennessee, to the extent they've interpreted that, have they uniformly held that that does not apply, that a lesser penalty does not include no penalty or appeal?
So I believe I was only able to find two where there are really court cases that address this particular topic, and both of those are very clear that they are that what the state is asking this court to do is what they held.
And that's the Kentucky and West Virginia opinions you referenced.
Yes,
correct?
Your Honor, Rogers and Easton.
Well, the Rogers case, that was not directly on point, is it? It seemed to reference another case that might have been more on point, but I didn't see a lot of in-depth analysis in Rogers that would be helpful here.
That's correct, Your Honor. Rogers relied on a Kentucky case from, I believe, 1919. And I've cited it in my brief, and that would be
Right.
slightly more on point, but Rogers used that logic to reach its conclusion.
Relied on Commonwealth versus Louisville.
Yes, Your Honor.
Railroad. If
So again-
we agree with your position, should this go back for resentencing?
I don't think that's necessary, Your Honor. There was a full sentencing hearing. The trial court made its considerations and imposed a sentence, and based on its order, the only reason that it vacated the sentence and fine was because of what the state believes is a misinterpretation of the lesser penalty provision. The court said, no penalty is a lesser penalty, so that's what you get. And so I think if this court were to agree with the state, then it can simply reinstate that sentence. I see my time is getting down. If there are no further questions, we respectfully ask that you reverse the judgments. Thank you.
Good morning, Your Honors. May it please the Court. Brennan Wingirter with the Appellate Division of the Public Defenders Conference. I'm here along with my colleague, Jessica Butler. Collectively, we represent Mr. Deberry and the three other similarly situated defendants who were arrested in the 26th Judicial District and who were convicted before this law changed but sentenced after this law changed. Before I want to do my best to respond to some of the questions that have been raised, but I do want to emphasize a few points, if I may, at the outset. What the state is asking this court to do is to reinstate prison sentences for 4 individuals who, as far as we know, are the only 4 who were caught in this limbo period where the 26th Judicial District sought to prosecute them and continue to impose prison sentences, which is contrary to the will of the legislature. For these particular individuals, for Mr. Deberry, who's now 47 years old, is a 5-year prison sentence. For Mr. George Person, who's almost 60 years old, it will be a 12-year prison sentence because they ran 2 6-year HMVO convictions consecutively. For Mr. Austin, who's 57 years old, he's facing 4.5 years. And for Mr. Carter, who just turned 59 years old, it will be another 6 years in prison. Collectively, that would cost the state of Tennessee about $750,000 in incarceration costs
But how
alone.
is that even relevant, the cost? We could say that for every single criminal prosecution, especially death penalty cases. How is that relevant?
Your Honor, I think why it is particularly relevant, and this goes to Justice Bivens, your question about the legislative history, the legislative intent. The reason for the amendment to the MVHOA statute, as expressed by our General Assembly, was to reduce punishments, to reduce incarceration costs, and to save the state of Tennessee funds in incarceration. That's why it's relevant to that.
But how is that relevant to the question before us, though? Because what we're really interpreting is the saving statute, right? I mean, so I understand your argument and the impact of it, but the saving statute long preexisted all of this.
That's correct, Your Honor, but I don't think we're looking at the saving statute alone here. So what we're looking at is the lesser penalty phrase from the saving statute and what it means. And on that point, I'll note, it does not say that the subsequent act has to expressly provide for a lesser penalty. The state keeps using the word expressly. The statute does not say that. The plain language of the saving statute is whether the subsequent act provides for a lesser penalty.
So what's the lesser penalty here?
So the lesser penalty here, Your Honor, that's where the amended statute comes in, why I think you have to look at both. So the question is whether there's a lesser penalty. If you start with just that language, forget about the MVHOA amendment for a moment, just that language of lesser penalty. The word penalty is a disadvantage, a hardship, a loss. It's not limited to a sentence. More particularly, it's not limited to prison time. So that's that word penalty, first of all. When we look at whether the subsequent act, so that's amended 601 as the state referenced, 5510-601, the question is whether that subsequent act provides for a lesser penalty. I disagree that it is very clear and unambiguous about whether that happened, because that's why we're here arguing this case. I think that the amended MVHOA statute implicitly provides for a lesser penalty.
Ms. Wingardner, do you concede that the no penalty is a lesser penalty argument doesn't fly?
Yes, Your Honor. We did not argue that in the Court of Criminal Appeals.
Well, let me ask you, are there any cases in our state that talk about administrative fees and such as lesser penalties?
I don't know that there is case law specifically. What we are relying on, Chief Justice Page, is first, the plain language of the word penalty. Second, the administrative process that is provided by the subsequent act, and I can talk about the Department of Safety regulations in just a moment. And then also the Attorney General's opinion we cited in our brief, saying that the legislature, number one, but this is case law actually, that the legislature is tasked with determining the appropriate punishment for criminal offenses. And in this situation, the legislature intended to reduce those penalties. And the AG's opinion says if the legislature wants to punish a Class E felony conviction by fine only, it may do so. So I think there's a couple ways the court can find a penalty here. We've talked about the collateral consequences. I agree those aren't traditionally part of a criminal sentence like we think about. But again, the phrase that we're looking at is lesser penalty. And so we have those collateral consequences. We have the administrative fees. We also have the fines.
So tell me, if we accept your argument that the collateral consequences can equal a penalty in this case, I want to isolate the penalty that is associated with driving as a motor vehicle habitual offender. The statute, the amendment/repeal statute talks about the process for reinstating a driver's license. How is that different for, that's just for somebody who has the status of a motor vehicle habitual offender. But Mr. Deberry and the others were convicted of driving. So what is the enhanced collateral consequence that flows from a conviction for driving as a habitual offender?
It is $153. It is $153 that no one else, not Mr. Coleman, not anyone else who may have their driver's license revoked, would ever have to pay.
And that's for reinstatement of the driver's license? That's an additional fee that Mr. Deberry would have to pay if he wants his driver's license?
Yes, Your Honor.
Is there any other collateral consequence that flows from a conviction for driving as a habitual offender?
No, I don't think so. I think what is provided for by the subsequent act, by amended 601, is this administrative process for reinstatement. What the Department of Safety has then provided for as the punishment is a $103 reinstatement fee plus a $50 SR-22 fee. Those fees, those penalties, are only imposed on people, Justice Kirby, as you point out, who were convicted of the HMVO offense.
Can you just walk, oh, I'm sorry.
No, go ahead.
Can you just walk us through how, I understand that your argument is that the statute, the amended statute, doesn't expressly provide for these. It does so impliedly. Can you just walk us through that argument? What other statutory provisions require or allow the Department of Safety to impose these fees, the extent to which the Department of Safety has discretion in choosing what fees to impose and on whom?
So I agree, Justice Campbell, I think that this is a unique circumstance, first of all. And I think that to answer that question, to walk you all the way through, again, we have to look at both the savings statute and the amended 601. When we ask whether this subsequent act provides for a lesser penalty, I acknowledge it has to be implicit. It is not expressly provided for. I don't think it has to be express. When we question whether the amended 601 implicitly provides for a lesser penalty, number one, I think that's ambiguous, which can get you to the legislative intent. Well, I should say number two. Number one, just the plain language is the administrative process through the Department of Safety. That process, it very clearly delineates between the status offense of HMVO and the conviction for HMVO.
And those are that's just the Department of Safety's
That's
administrative
correct.
process. Is there any statute that requires the Department of Safety to treat status offenders and driving, with the status offenders differently?
I understand. I cannot say for sure whether there's I am unaware of a separate statute that would require that additional $153 that I'm talking about.
Could the Department of Safety change that tomorrow?
I assume that they could, yes, Your Honor.
And if they did, and if they just got rid of that administrative fee or the differentiation, I mean, what does that do to your argument?
I think it does nothing to this particular argument because what we have here is not a punishment-free prosecution, as the state keeps saying. Our position is that those administrative fees are the most direct penalty that is imposed through amended 601.
But if the administrative fees just go away?
Then the second option that I would offer for this court, and I think one of your honors mentioned this earlier, is the reinstatement of the fines associated with the sentence itself. So for Mr. Deberry, there was I believe it was either a $1,300 or a $1,500 fine that was imposed along with his 5-year sentence. And I think in one of these other cases, one of the Court of Criminal Appeals judges asked that same question of, well, what if the trial court had left the fine intact? Would that have been a lesser penalty? I think the answer is definitely yes. And so I think another way to effectuate the legislature's intent here is to reinstate those fines, which are the
What is the source of the fine? What is the?
That is statutory, Your Honor.
That is statutory?
Yes.
Which statute?
That is under the HMVO offense was punishable by, I believe it was 4 to 6 years, because all of these gentlemen are career offenders, so it's increased punishment. So it's 4 to 6 years up to $3,000 in fines.
And in what way does it make sense to kind of cherry pick punishments from the old statute?
Because that's exactly what the legislature has told the courts to do in this particular instance. The reason that the legislative history here is so important on the amended MVHO statute is because we are disagreeing on whether the amended statute provides for a lesser penalty. That makes it ambiguous. Then when this court turns to that legislative history, this is one of the most express statements of legislative intent I think I've ever read, where the sponsor of this bill, the amended MVHO statute, said repeatedly, we are talking about reductions in incarceration. We don't want these people to do prison time. We want them going back to work. This is a status offense. We want the punishment to fit the crime. Everything about this bill was intended to remove the incarceration portion of the sentence.
And did it accomplish that for any individual who drove with an MVHO status after this amended statute was passed and it became effective? Was the legislative intent that you're describing, was it effectuated for any individual who committed this conduct after the act became effective?
Yes, Your Honor, because after it became effective, there is that felony offense, I agree, is no longer there. It is no longer a Class E felony to commit this act. So what we have, and where we think the saving statute was intended to come in, was to catch those people in the gap, like Mr. Deberry and these other 3 individuals, where they were convicted before but sentenced after.
Ms. Wingardner, I want to go back for a moment to the Department of Safety regs that we're talking about. Those provisions were in place before the amendment was adopted, correct? Those have not been changed since enactment of this statute, correct?
Not to my knowledge,
And the
Your Honor.
statute did not address those at all,
The
correct?
statute simply left it to the Department of Safety to come up with the correct process. That's correct, Your Honor.
So isn't there an argument then that the new statute didn't provide this as a lesser punishment? They were simply abolishing or repealing what was there to begin with. This was already out there. This is not something that they're providing for a lesser punishment.
So 2 points on that, Your Honor. First, we're talking about a a repeal or amended statute, not just a repealed criminal offense. So I think the saving statute language is broader than that. And number two, the administrative financial fees were already in place. Those were not eliminated. So because they are still there, they do become by default, our argument is at least, that those by default are the lesser penalty that remains, again, implicitly provided for by the amended statute, which puts this into the hands of the Department of Safety. If we're going to presume that the legislature knows what it's doing when it is acting, then we presume the legislature knew that these additional fees, these additional penalties still existed. And they did not intend for those to go away for people like Mr. Deberry who have the conviction, again, separate from the status offense on their records.
Did the statute require Mr. Deberry to seek reinstatement?
No, Your Honor, did not.
So if he chose to, if he chose not to seek reinstatement, there would be no administrative fees. There would be no $153 fee that would constitute a penalty.
That's correct, Your Honor.
So-
Yes, we acknowledge that.
So he basically, by seeking reinstatement, just voluntarily incurs that fee,
So-
correct?
That's true that it wouldn't, he does not have to pay $153 if he does not seek reinstatement of his license. That is true. However, if he does not, again, I'd reiterate, this is not a punishment-free prosecution, if that's the phrase that we're talking about here. There are plenty of other punishments that are still being imposed. I think that's why we have to go back to lesser penalty, the word penalty, not the word incarceration or prison time.
Can we go back just a moment just to this reinstatement process? Is Mr. Deberry even allowed? I understand that he's not required to seek reinstatement. Is he allowed to seek reinstatement under this amended provision?
It's not in the record, Your Honor, but to answer your question, we've made some phone calls to court clerks, and I think the answer is yes.
That would depend on whether he has other driving revoke offenses.
Yes, Your Honor. And so these four individuals are not all in the exact same position. I'll be clear about that. Each one will have to go to the county where their conviction occurred, where their HMVO order was entered, and go through all of the hoops associated in both of those counties if they're different in terms of reinstatement.
And they would be seeking reinstatement under this provision specifically?
Yes, Your Honor, I believe so.
Okay.
So let me make sure I understand the current landscape. For somebody who drives as a motor vehicle habitual offender currently now, there's no incarceration and there's no fine, right?
There is no criminal conviction and therefore no prison sentence or fine on a judgment form.
Okay, all right.
Yes, Your
So when you were referring to previously, well, don't incarcerate him, just reinstate that fine, that's also under the prior statute. There's no fine in place now. Okay.
Yes, Your Honor, I apologize.
Because it's just basically not an offense now.
Correct. And so that's our position is for these four individuals who are in that gap, that limbo period, again, to speak about general fairness, the rule of lenity, all of that we argued in our brief, reinstatement of the fine, if the court feels that the administrative fee, that is, as Your Honor acknowledged, not always going to be imposed, we think that would be the most fair and just result here is reinstating those fines or remanding for imposition of fines. Because again, Mr. Deberry's was just the first of these four. And so I think you'll see in the progression of the other three, Mr. Person, Mr. Austin, and Mr. Carter's cases, the trial courts said, well, we don't really know what's going to happen now. So for Mr. Person, he's one of my other clients, they hinted he was going to get 6 years consecutive, but the judge said, well, and if the appellate courts tell me I'm wrong, we're just going to have to come back here and sort all of this out. So I do think a remand, Chief Justice Page, would be appropriate for all four of these cases to let the two trial judges, because we have two different trial judges here, to sort all of this out depending on what the court decides.
You're talking about us reinstating. What's the source of our authority to simply reinstate the fine and nothing else?
So that, with that, Your Honor, again, I think we are relying on the ambiguity in the amended 601 about whether it provides for a lesser penalty.
But aren't we basically rewriting the statute if we do that?
I don't think so, Your Honor. No, I think all the court is doing is looking at the amended MVHO, which says there's this administrative process to the Department of Safety. When there's ambiguity in whether that's a lesser penalty, we can turn to legislative history and other sources. We have two other main sources. We have an Attorney General opinion that says it's perfectly acceptable to punish Class E felony convictions by fine only. That's number one. And there are other.
And the legislature can do that, but how does the court do that?
So in this instance, the court does it by deferring to the legislature's statements in the history of this amendment, where they repeatedly said they wanted to get rid of incarceration.
But again, we're supposed to go by the language of the statute, not what the legislative history does to, in essence, amend the statute.
Except for when the statute is ambiguous, Your Honor. And that's our position, is that because we're arguing about whether a lesser penalty has been provided, the court can and should look to that legislative history, which makes it very clear that the prison time portion of the sentence is the only thing our legislature was interested in targeting.
Did they discuss fines? Was there any mention of fines in the legislative history?
No,
So
Your Honor.
do we really know what they intended in terms of fines, other than the language of the statute?
I think that what we take away from the legislative statements is they don't want these individuals serving prison time for these offenses.
But they don't want them fined either. They eliminated that.
Well,
I mean, it's sort of a split the baby down the middle kind of, and I mean, it's just speaking only for myself, it seems like our authority would be limited to either having him sentenced under the prior statute, whatever it's comprised of, or not, because there's no penalty going forward. So, I mean, no incarceration, no fine. I understand your collateral consequences. I don't mean
Right.
to minimize that.
No, I understand, Your Honor. And I think, again, that's where lesser penalty comes in. And we agree, if you find that there is no penalty, that's it. That's why we are arguing there is actually still a penalty here, sure, though it may be implicit.
Well, and the legislature made this effective July 1, 2019. They could have backed that date up, could they not, to take care of people caught in the gap? Would that have been possible?
They could have, Your Honor. What we have here, though, is a situation where I don't want to speak for our legislature where this isn't spoken, but I think they probably did not expect that anyone would get caught in this gap. And I want to make a point on that. This is relative to footnote 3. You mentioned footnote 2. Footnote 3 in the state's reply brief says that these are not the only 4 individuals and that this is not the only judicial district where this is occurring. I want to be very clear that Knox County case where Mr. Coleman was the Assistant Attorney General is in a different procedural posture. That Knox County case defendant was both convicted and sentenced before this MVHO statute was amended. So hearkening back to the Kesey and Menke theft cases, that just does not apply here. These 4 in this one judicial district, and frankly, under one trial judge in this judicial district, are the only 4 that either my office or the Attorney General's office are aware of where they were caught in this gap. And that we established that on the record in these 4 other cases. The state admitted that in at least one of the 4 cases in the Court of Criminal Appeals, that this is limited to these 4 in this one judicial district.
What difference does that make to our case?
So only to emphasize the point, I think that Justice Kirby and Justice Lee were getting to about the general fairness of it and what the legislature had in mind when it was enacting the change, that I think what we can gather from the history of this is that every other jurisdiction either dismissed these cases or stopped prosecuting them, and these are the only 4 who were caught in that limbo.
But again, that's not our call, is it? I mean, that's like the use of the burglary statute in the Walmart cases out of Knox County. I mean, a lot of us didn't like that either, but that was happening only in one judicial district. But this court ended up saying that's the clear language of the statute, whether we like it or not.
And I agree. And in this situation, though, Your Honor, the amended statute, the amended MVHOA in 601, is ambiguous on whether a lesser penalty is provided. That's what gets you to the legislative history. All we're asking this court to do is effectuate the legislative intent here, which is to stop incarcerating these individuals. And these are the only 4 that we're aware of that would get the benefit of not having to serve prison time, though they will still have that Class E felony conviction on their record, and the court could reinstate the fine. We're aware of that. But it's the prison time that was really targeted by the legislature that we're asking this court to affirm that portion of the
But the
lower courts.
legislative intent was for anyone who committed this offense after July 1, 2019, for there not to be a prosecution. It wasn't for anyone who committed this offense any time, any place. I mean, it seems to me they drew a very clear dividing line there between July 1, before and after. And if you fell after July 1, no prosecution. Before July 1, the old law applies and Could be prosecuted.
And I think that's where the saving statute comes in, because after July 1, 2019, there's no prosecution at all, right? So for these four gentlemen who are caught in the middle, they've already been prosecuted to the extent it includes a punishment, a sentence. Our position is that's where the lesser penalty provision kicks in. It may be implicit, we acknowledge that, but it is still there. They are not getting off scot-free, as the state has suggested.
Well, this defendant was driving in May of 2018, if I recall, so 13 months before this went into effect, really 13 and a half. And if the sentencing hearing had been on June 30th instead of July 8th, we wouldn't be here today, would we?
That's correct, Your Honor. That's what happened in the theft cases. I had a client who ended up doubling his time because of the way the court held, but that's how the timing works. And that's why that Knox County case cited in footnote 3 of the state's brief, that would be that scenario. That is before this amendment change. It has nothing to do with this case. It's just these four that are caught in that gap.
I mean, isn't there always, the line has to be drawn somewhere,
Correct.
right? I mean, there is always going to be some seeming unfairness in that, there are going to be, I mean, there's no question, as I understand your argument, there's no question that defendants who committed the conduct before this statute, the new statute became effective and were sentenced before that, they are serving prison time. You're
That's
not
right.
here
We're not
arguing
asking
that
for
they should get the
retroactive.
benefit of this.
Correct, Your Honor.
And so the line is always going to have to be drawn somewhere. Am I correct that when these defendants committed this conduct of, driving after having their license revoked as an MVHO, that the statute, there was a statute making that a Class E felony and with the potential for prison time? Is that
Yes.
right?
Correct, Your Honor.
And you're still maintaining that there is something unfair about punishing them with prison time for that conduct?
Only because the statute was amended before they were sentenced, yes. And that, our position is, that is the entire purpose of the saving statute. When the legislature has not expressly provided for retroactive application, which we're not talking about here, I'm not talking about people sentenced before the law changed, just for people caught in limbo, just for these four individuals caught in that gap, that is where we are asking for the general saving statute to kick in, because the subsequent act, amended 601, at least implicitly does provide for something less than prison time.
Did you find any legislative history for the second sentence in the saving statute that is illuminating on this at all?
Frankly, no, Your Honors.
I didn't see anything
No.
that looked particularly long.
No, and I think the only part that's relevant from the saving statute is the phrases subsequent act. Do we have one? The answer is yes. We have amended 601. And then the phrase lesser penalty. Do we have one?
Okay.
There's the ambiguity in the MVHOA, which then gets you to the legislative history about reducing penalties and eliminating prison time.
Okay.
I certainly understand if you don't know the answer to this question, but there's something rattling around in my head. Aren't there previous statutes out there that have said effective as of this date for offenses committed as of this date and for any sentencing for this offense? In other statutes, not this one, I'm talking about hasn't the legislature in previous instances, and I can't cite you to a provision, but there's something that makes me think there are other statutes out there where they have said it's effective as of this date, not only to offenses committed as of this date, but also to any sentencing done after that date.
So the only one that I can think of off the top of my head is the recent probation revocation statutes that say that it applies to any hearings held after this date, which might be what Your Honors is remembering. And I think in that instance, if they had done that here, then we would have an expressly provided situation by the legislature.
Oh yeah, I don't think
Right.
everybody would agree that that would be very clear if that were the case.
Correct, yes. And unfortunately, it's not as clear. We have the implicit, we have the ambiguity.
But by implication, you could also say they considered that and didn't put it in.
I think by implication, though, Your Honor, they know that the saving statute does exist. They are aware of this prior statute, and perhaps they thought that the saving statute would catch these individuals in the middle. The problem is that it's not expressed, again, because it is implicit with the ambiguity. We're asking this court to look at that legislative history of the amendment in eliminating the prison portion of the sentence.
So your main argument, I want to make sure that I understand your main argument, is that the remaining $153 in administrative fees for reinstatement of the driver's license after conviction of driving as an habitual offender, that remaining administrative fee is the lesser penalty under the saving statute.
Yes, Your Honor. I think that is the most logical understanding of getting from subsequent act, providing for a lesser penalty, what it does. That is the most direct line to that. We've offered reinstatement of the fines as an alternative if the court does not feel that the reinstatement is sufficient. If there are no further questions, we ask this court to affirm the removal of the incarceration portion of the sentence and leave only financial penalties for Mr. Deberry and these 3 other individuals. Thank you, Your Honors.
Good morning again, Your Honors. I'd like to first clarify something and make sure it's very clear. This does not affect only 4 individuals. Specifically, when it comes to MVHO, there's at least one other individual in East Tennessee who is making the exact same arguments. And while the procedure is slightly different, I think that case is poignant because while this act came into effect in 2019, that individual in East Tennessee did not, he was sentenced before 2019, in June of 2019. His motion for new trial, because of the COVID-19 pandemic, did not occur until 2020, late 2021. And so there are cases that could still very easily be in the pipeline specific to MVHO convictions. But more importantly, this determination on the statutory meaning of lesser penalty in the saving statute applies much more broadly. Especially if this court were to affirm the Court of Criminal Appeals and the trial court's determination that no penalty is a lesser penalty, it would impact every single criminal repeal from now on, unless the legislature created some specific language when they created that repeal. So I think it's important to note that this is not a decision limited to 4 individuals. To go to the defendants, as I think you put it, Justice Kirby, their main argument, this administrative fee is not a lesser punishment for driving after being declared an MVHO. First and foremost, the easiest way to sort of knock that argument down is to say it is 100% completely optional, as you pointed out, Justice Lee. The defendant is not required to attempt to reinstate his license in any way, shape, or form. It is not a punishment imposed as a consequence to his conviction. The trial court is not putting that on his judgment form. There is nothing anywhere in the amended...
How is he not penalized for having been convicted of driving as a motor vehicle habitual offender? Penalized doesn't necessarily equal incarceration.
Correct.
How is he not penalized for having had that conviction? I mean, it is an adverse effect.
It is.
And that seems to be a synonym for penalty. I mean, how is he not penalized for having that conviction?
So 2 points. Again, Your Honor, first, it is not something imposed on his conviction. It is not something the trial court is saying you have to go and pay this fine.
But it's something that nobody else in the universe has. Nobody else in the universe has to pay that additional $153 if they want to have their driver's license reinstated. Everybody else has the freedom to do that. So how is he not penalized for having sustained that conviction?
So 2 additional points. So first, while no one has to pay specifically $150 for reinstatement based on a conviction of driving while MVHO, the Department of Safety has a long list of fees and costs associated with the reinstatement of one's license based on various convictions, based on various administrative tasks and things of that nature. I know of at least one that I believe is $250. And so these costs are associated with
are you disputing that Mr. Deberry and the others, are you saying they would not have to pay this additional $153?
No, we're saying that is not a penalty. And the defendant has focused on sort of the plain language of penalty, and the state would direct this court
But how are they not penalized for having that conviction? I mean, the meaning of the word penalty.
Because penalty means that something has to be penal in nature. The Supreme Court has directed us to determine what is penal in nature. When a disability, a civil disability, if you will, this fee, has to be penal in nature. And in Trope v. Dulles, they said it's considered non-penal if it imposes a disability not to punish, but to accomplish some other legitimate government purpose. And when the Department of Safety has this long plethora of costs associated with paperwork and other things to get a license reinstated. And to your point, Justice Campbell, that's based on 50, I just had it.
You had it when you were sitting at the table.
5550-501 is my understanding of what they base that off of. And so it is non-penal in nature. It is something that deals with administrative costs and things of that nature. And most importantly, it is not mandatory. If the trial court cannot force this defendant to do anything, whether it be incarceration, a fine, or if the court forced him to go and get his driver's license, then it could potentially be seen as penal in nature or as a punishment for his offense of driving after being declared an MVHO. But the trial court was completely silent about this. The amended statute, if you will, is completely silent about this. And so for those reasons, we respectfully ask that this court reverse the judgments. Thank you, Your Honors.
Thank you, counsel. Mr. Hibbner, you may call the next case.